Chairperson. No, I did not receive any apologies, Chairperson.
Good, let's get going. Over the International Treasury, colleagues, we've been asking for this bill. It's here, it's been voted on, if I'm correct, in Kululeko yesterday in the NA committee, but it's not before the House. So ours is an informal briefing for now, which is allowed in terms of the rules. Let's go ahead, National Treasury.
Thank you, Chair. Thank you so much for the opportunity to present the bill, even if it's informal at this stage. I must apologize. I hope I'm audible and clear. I am experiencing load shedding at the moment. So if you require me to turn off my camera, please let me know.
You are to me at least. I'm not sure about others. If anybody's got an issue, they'll put it in the chat group and in Kululeko will pick it up. Thank you, my friend. Okay, go right ahead.
Great. Thank you. Chair, as you've rightfully indicated at the top of the meeting, this bill has been in the works for a while. It's been processed currently at the standing committee, and today we're going to provide an informal presentation as the processes in the standing committee haven't fully concluded yet. But just given the really tight deadlines, we thought that this would be an efficient use of the committee's time, and thank you for indulging us and providing the possibility to present this at the moment. Chair, at the start of, let me just apologize on behalf of the Director General. He wanted to be present and in fact wanted to make this presentation himself, but he has been held up by post-budget commitments. So from National Treasury, it'll be myself. We have colleagues from the legal department, Janine and MP. We have our acting Deputy Director General, Hoshu, as well as colleagues from the Financial Intelligence Center. Next slide, Janine. Next slide. So, Chair, I will start at the most logical place, which is the beginning. So South Africa is a member of the Financial Action Task Force, and they conducted a mutual evaluation, which is a peer review of the strength and rigorousness of the anti-money laundering and combating financial terrorism system domestically. That report was published in October 2021, and South Africa scored or was rated as very poor. There were two aspects of the review, and we performed very poorly in both. The first was the technical compliance aspect. Chair, this aspect measures whether we have the laws and regulations in place at all to effectively combat money laundering and terror financing risks and threats. On this portion of the assessment, we failed 20 of the 40 FATF core standards or recommendations, as they call them. The other part of the assessment measures the effectiveness. So how effective the system is in pursuing, identifying and pursuing those elements that represent the highest risks of money laundering and terror financing. There, Chair, we failed all 11 of the effectiveness measures. So that was 100% failure on this aspect. Chair, there was a combination of the depth or the severity of failure, but we did fail all 11. So as a consequence, South Africa faces grey listing at the February 2023 plenary meeting. South Africa has been put under an international cooperation review group called ICGR, and this is an observation period of a year ending in October 2022. South Africa is also under enhanced follow-up process, which requires more frequent reporting back to FATF as we move forward. This will be followed by a post-observation period report. So, and in the coming weeks, we will be presenting a report on where we are following this 1 year post-observation period. And there, Chair, we have to report on the progress we have made on addressing the failures that I spoke about in the two aspects above. So South Africa will submit a brief report at the end of August. Well, it would have been the end of August, but it'll be slightly later than that. It'll be in November, I believe. And a more detailed report at the end of October to report on the technical compliance and 11 effectiveness measures. And then, Chair, as I indicated, FATF will meet, the plenary will meet in 2023 to consider the recommendation of the group that will be assessing our progress, who are known as the joint group. Next slide, please. So, Chair, this gives you a sort of graphical representation of the technical compliance aspects and the failures that we, the overall failure of 20 of those 40 recommendations or standards. So, Chair, what we'd like to see is to be largely compliant or compliant, and that's sort of that brownish color and that gray color. And where you certainly don't want to be is non-compliant or partially compliant, and that's the very deep red and then that bright red. And as you can see, Chair, there's a huge amount of red there. Next slide, Janine. On the effectiveness, Chair, where we failed all 11, you'll see the ratings there being moderate or low, but those represent the two worst possible scores. What we'd want to see is substantial, which is yellow, or high green, and as you can see, Chair, there's none of that there. So according to FATF, Chair, we can clearly see that we have a lot to do on the technical compliance side, which is the bill that's in front of you right now, as well as the schedules that you had recently processed. And in addition to that, there's some heavy lifting that we need to do on the effectiveness part, as you can see, and that work is being coordinated by the interdepartmental committee chaired by the Director General of the National Treasury. Next slide, please. So, Chair, I have touched on this, but it's worth perhaps going into it in slightly more depth, how the FATF assessment works. There are two aspects. The first is an assessment of the letter of the law, the legal framework, laws and regulations. And Chair, as I mentioned, that is the general law, the content of the general laws amendment bill, as well as the POC Datara being processed by the Committee on Police, which is addressing part of the technical compliance failures. It's massively challenging, Chair, but in a way, this represents the easier part because it requires the amending and enactment of laws. The second bit, Chair, is much tougher, and that's the 11 immediate outcomes where we failed completely. Here, Chair, we need to demonstrate the success of the implementation of the laws, as well as the overall continued effectiveness of the system. It is a more subjective test, and therefore often harder to demonstrate progress. Next slide, please. Next slide, Janine. So, Chair, we aim to have significant progress on the technical compliance part, and like I said, that's the law part. We are prioritizing the 3 core FATF recommendations, but we're going to deal with as many as we can, which is the remaining 17 via amendments to current Acts of Parliament. Given the time constraints, Treasury has developed an omnibus bill which seeks to amend 5 acts falling under 4 different ministries. This was taken to Cabinet in August of 2022 and deals with the core recommendations. Chair, as I noted earlier, there is a separate Pokdatara amendment bill, which was tabled by the Minister of Safety Security, which deals with 2 of the core recommendation. So, Chair, the bill in front of you deals with 14 recommendations. The Pokdatara deals with 2, and the 4 outstanding aspects are dealt through secondary or subordinate legislation. And Chair, as I've noted, that there are significant time constraints. The IDC has constituted working groups to work urgently on the omnibus, and the institutions and agencies that have been involved in developing the bill in front of you are of course ourselves, but the Financial Intelligence Center, the Department of Justice and Constitutional Development, Social Development, the Surveillance Secretariat and Police, the DTIC, the Companies and Intellectual Property Commission, the Reserve Bank, the Prudential Authority, and the South African Revenue Service, as well as the Financial Sector Conduct Authority. Next slide, please, Janine. So, Chair, the omnibus covers these following 5 pieces of law that I referred to. The first is the Financial Intelligence Center Act. And this represents the lion's share of the amendments, but there are also significant amendments being made to the Non-Profit Organizations Act, the Trust Property Control Act, the Companies Act, and the Financial Sector Regulation Act. And Chair, as I've noticed, the bill addresses 14 of the technical compliance deficiencies, and these are recommendations 7, 8, 12, 15, 17, 18, 22 through 28 of the table that I showed earlier. Pokdatara deals with recommendations 5 and 6, and the remaining 4 deficiencies, Chair, as I mentioned, are being dealt via regulatory and policy interventions. Next slide, please. So where do these amendments fit in the FATF grey listing notice? So, Chair, the legislative amendments in the 2 bills, being Pokdatara and the General Laws Amendment Bill, and in front of this committee today, will collectively deal with 16 of the 20 deficiencies. They are important and significant remedial. They represent important and significant remedial action to prevent grey listing. In a way, Chair, sorting out technical compliance, which is the laws, is almost the price of entry. It is the minimum step required to prevent a grey listing. If we cannot get this part right, the entire effort to avoid grey listing really becomes impossible. So we will report at the end of August to FATF, at the end of October, that should be on 2 bills tabled in Parliament. Our hope is that we can report by the end of October, which is actually now latest November, excuse me, that Parliament has made significant progress in passing the 2 bills, and report that by December that both bills have been passed. We hope that we have to make both bills effective by very early 2023 in January. However, Chair, these amendments to the laws are, like I've indicated, are not enough to avoid a grey listing. They are necessary but not sufficient. We still need to demonstrate effectiveness in implementation, which is that more difficult part that I referred to earlier. And here, Chair, South Africa will have to demonstrate to FATF plenary in 2023, February, that we have started and made sufficient and significant progress to avoid being grey listed. Next slide, please. Chair, like I mentioned earlier, what your committee will be seized with is the technical compliance bit. But for completeness sake, I thought it would be appropriate just to take you through the other part, which is the effectiveness part as well. Chair, there are specific interventions that we need to make there to be able to demonstrate effectiveness in those 11 areas. And they're called immediate outcomes in FATF speak, but there are sort of 11 areas that we have to demonstrate significant improvement in effectiveness. The first IO1 is on the policy framework, and that requires the development of national risk strategies and assessment. The second part, IOs 3 to 5, those, Chair, are regulatory issues involving various supervisory requirements, including beneficial ownership information. IO 6 to 8 and IO 2 relate to investigations, prosecutions, forfeiture relating to money laundering. IOs 9 to 11 relate to terror financing, investigation and prosecution, as well as targeted financial sanctions relating to terrorist financing and proliferation financing. We will have to demonstrate significant substantial progress in implementing the recommended actions, as well as develop our own action plans per IO by February. Chair, another reason why I think it's really useful to have a sense of both sides of it is that there's clearly a lot of interaction between the law and the regulation, as well as the effectiveness. You can only, in a sense, be effective. You can only be measured on how effective you are by the minimum laws and regulations that you have. So there's a very important overlap. So it's, I think, useful for the committee to be aware of that. So how does FATF assess progress in each IO? Chair, effectiveness is assessed in a fundamentally different way to that of technical compliance or the law part. The assessor's conclusions about the extent to which a country is more or less effective is based on the overall understanding, on jurisdiction's overall understanding to the degree to which the country is achieving the outcome. So it's outcomes based. The core issues should not be considered as a mere checklist, but really being able to demonstrate the appropriate and effective outcomes in all the areas that the intention and the spirit of the laws are being met. For each immediate outcome, there are two overarching questions that the assessors will try to answer in assessing whether our system is effective or not. So the first question is, to what extent are the outcomes being achieved? So the assessors here assess whether the country is effective in relation to the outcomes, i.e. whether the country is achieving the results expected of a well-performing AML-CFT system. They should base their conclusions principally on the core issues, supported by examples of information and examples of specific factors, and taking into account the level of technical compliance and contextual factors. So here, Chair, the assessors will be looking at, well, how many prosecutions are happening, how many investigations are happening, and do those comport with the areas that we identify as being high risk. The second part, Chair, is what can be done to improve effectiveness. And here the assessors will seek to understand the reasons why a country may not have achieved a high level of effectiveness, and where possible, make recommendations to improve its ability to achieve those outcomes. Next slide, please. Chair, I'm going to take a moment to explain how we've been coordinated internally within government to try and minimize and how to avoid address the deficiencies identified in mutual evaluation and therefore avoid a grey listing. I'll go through this relatively quickly, Chair, but Cabinet mandated a interdepartmental committee to coordinate all the actions, all the required improvements across a wide range of areas through an interdepartmental committee, which is chaired by the Director General of the Treasury. And at the second level, there are specific committees that have been put together to address the individual IOs, which have been grouped together functionally. And there, the Director General chairs those specific committees as well. Then below that, there's the multi-departmental and multi-agency working groups that are working to address the specific identified deficiencies. Next slide, please. So, Chair, the FATF process from now until the key event in February 2023 is as follows. We can update the October report in November, which we're currently working on, and we will begin to engage with the FATF on progress that we have made. We will then have a face-to-face meeting with the Joint Group for Africa and the Middle East in January 2023 to demonstrate the substantial progress on the recommended actions. So unfortunately, Chair, I think for many of the Treasury and FIC colleagues that are on this call, it'll be a very, very short holiday. The Joint Group will then provide a report to FATF on February 2023 at the plenary meeting where a final decision will be made. And then lastly, Chair, greylisting will involve a decision which represents action plans that we need to meet to exit the grey list. Next slide, please. Chair, so that I hope wasn't too long, Chair, but I thought that the context of what we're doing, demonstrating some of the timelines, as well as understanding what the content of what we seek to do would be really important context in this briefing presentation. Chair, I'll now hand over to Janine to take us through the clause by clause what we seek to amend in the various pieces of legislation. And then, Chair, finally, I will make some concluding remarks in the final slide. Janine.
Thank you very much, Honorable Chair and Honorable Committee members and stakeholders. So we will now briefly summarize the key provisions in the bill. So the first part of the bill provides for some amendments to the Trust Property Control Act, and this is in clauses 1 to 7 of the bill. And the FATF recommendation requires countries to put in place measures to prevent the misuse of trust for money laundering or terrorist financing purposes. And it's emphasized that countries should ensure that there is adequate, accurate, and timely information on trusts, including information on who the trustees and beneficiaries are that can be obtained or accessed in a timely fashion by the relevant authorities. So the proposed amendments to the Trust Property Control Act address the specific deficiencies that have been identified relating to trustees and the ability to obtain full information on beneficial ownership when in relation to trusts. And so clause 1 of the bill provides for a definition of accountable institution that's aligned with the FIC Act, and a definition of beneficial owner for the purposes of the Trust Property Control Act that particularly tries to indicate how that concept is appropriately defined in the specific context of trusts, which is a very distinct context from, for example, with companies or other types of institutions. So it's necessary to provide a very specific and well-crafted definition so that it appropriately applies in this particular context. And clause 2 amends Section 6 to specify matters that would disqualify a person for acting or continuing to act as a trustee. And that's very important, to be able to ensure that persons who aren't appropriate are not able to be appointed or to continue to act as trustees. That's a very important aspect to try and prevent trusts from being potentially abused. Clause 3 amends Section 10 to require a trustee to disclose their position as a trustee to any accountable institution with which the trustee engages in that capacity, and to make it known to the accountable institution that the relevant transaction or business relationship relates to trust property. Clause 4 amends Section 11(1) to require a trustee to record the prescribed details relating to accountable institutions, which the trustee may use as agents to perform any of the trustee's functions relating to trust property, and from which the trustee obtains any services in relating to the trustee's functions or relating to trust property. And Clause 5 inserts a proposed new Section 11A that specifies the information that must be kept by trustees in relation to the beneficial ownership of trusts, and requires the master of the High Court to maintain a register that contains the information relating to the beneficial ownership of trusts, and it also enables regulations to be made regarding the access to information regarding the beneficial ownership information. Clause 6 amends Section 19 to specify that a failure by a trustee to perform duties in terms of specified sections 10 subsection 2, 11 subsection 1DA, and 11A subsection 1 would be offenses. And so this would provide some strong sanctions in relation to some of these key requirements that are being proposed in relation to obtaining and reporting the specified critical information. Clause 7 amends Section 20 to specify that a trustee may be removed by the master if the trustee becomes a disqualified person to continue to act as a trustee. The next part of the bill, clauses 8 to 14, addresses some amendments to the Nonprofit Organization Act, and the FATF relevant recommendation requires countries to ensure that the regulatory framework ensures that nonprofit organizations are not potentially able to be misused for terrorism financing activities. And it requires countries to review the adequacy of their legislation relating to nonprofit organizations and the regulations in terms of that legislation. And so to ensure, that they're appropriately strengthened to be able to protect the nonprofit organizations from being vulnerable to terrorist financing abuse. And Clause 8 amends Section 2 to update the objects of the Act to align with other proposed amendments relating to the registration of certain nonprofit organizations as being mandatory and requiring compliance with the Act, particularly relating to governance, transparency, and accountability. And Clause 9 amends Section 5 to insert a new subsection 2 that would enable the Directorate of Nonprofit Organizations to enter into arrangements that allow for collaboration, cooperation, and coordination by the Directorate of Nonprofit Organizations to be able to carry out its functions effectively. And so this is intended to be supportive and capacitating for the Directorate of Nonprofit Organizations. And Clause 10, amends Section 12 to make a registration of specified nonprofit organizations mandatory, so that the Nonprofit Organizations Directorate's oversight will apply to those required nonprofit organizations. Clause 11 amends section 18 to require nonprofit organizations to submit prescribed information about the office bearers, the control structure, governance, management, administration, and operations of nonprofit organizations to the director. So this is ensuring that a relevant, important information is gathered and made available ultimately to relevant authorities, to be able to monitor and ensure that nonprofit organizations are not potentially being subject to terrorist financing abuse. Clause 12 amends section 24 to include information about the control structure, governance, management, administration, and cooperation and operations of nonprofit organizations in the register that the director is required to keep, and provides for access to that required information. And then clause 13 inserts a new chapter 3 and section 25A into the NPO Act to provide for grounds for disqualification of persons to be office bearers of a nonprofit organization, and also to enable potentially that a person who becomes disqualified would be able to be removed as an office bearer if they become disqualified or fail to comply with certain requirements of the Act. And clause 14 amends section 29 to include offenses relating to the power to comply or contraventions relating to the power to comply with section 12 and section 18(1) subsection BA of the Act. And then next, a very substantial proportion of the bill relates to amendments to the Financial Intelligence Center Act. And these address a number of these identified recommendations, and it seeks to address the shortcomings that were highlighted that should be addressed through strengthening the FIC Act. So there's a recommendation 7 that relates to targeted financial sanctions on proliferation financing. And then there's recommendations 10, 22, and 23 that relate to customer due diligence. Recommendation 12 that relates to politically exposed persons. Recommendation 17 that relates to reliance on third parties. Recommendation 18 that relates to internal controls and foreign branches and subsidiaries. And then recommendations 26, 27, and 28 relating to Schedule 2 of the FIC Act that addresses supervision and enforcement. And so the following immediate outcomes will also be positively impacted by the proposed amendments to the FIC Act. And these would be immediate outcomes 3 and 4 that address regulation and supervision, and immediate outcome 6 that addresses the use of financial intelligence. And a large part of the technical compliance deficiencies that South Africa is required to address involve amendments to the FIC Act and the schedules to the Act. The committee has very recently processed amendments to the schedules, which relate to and are certainly helpful to be promoting the compliance with the FATF recommendations. And the committee's processing of the amendments is greatly appreciated. The amendment to Schedule 1 of the FIC Act, containing a list of accountable institutions falling within the scope of the FIC Act, has addressed the scope issue that affects customer due diligence recommendations, and this has now been approved by Parliament, and Parliament's very prompt processing of the schedules is certainly very greatly appreciated and greatly assistive of the efforts to comply with the recommendations. And much of the amendments to the FIC Act that are proposed in the bill are quite technical in nature and do not substantially change the basic principles on which customer due diligence provisions are based. And it does, however, promote the strengthening of a stronger AML-CFT proliferation financing regulatory framework. And so Clause 16 of the bill amends the objective of the FIC in certain respects, in particular to include in the objectives that it also includes the identification of persons involved in money laundering activities, terrorist financing and related activities, and proliferation financing activities. It also includes the objective of producing forensic evidence relating to the flow of financial transactions, and also it also promotes the FIC to share information with the Auditor General. That's another objective that's now included, would be included, and also by amending the term an investigative division in an organ of state to refer rather to a national department, to remove any ambiguity as to whom the FIC may share information with. There are a couple of amendments to the general powers of the Financial Intelligence Center that are provided for in Clause 18. And these are the power to enter into public-private partnerships in order to achieve any of the objectives of the center, and also for the FIC to perform its functions effectively, its powers to request information or access to databases by other organs of state, and also to have access to information in a register that is kept by an organ of state would now be specified. Then several clauses of the bill, clauses 20, 21, and 37 to 42, address matters relating to customer due diligence. And Section 21C would be amended to provide for instances where the accountable institution suspects that a transaction or activity is suspicious in terms of Section 29, and the institution reasonably believes that performing the customer due diligence measures in terms of Section 21C may disclose to the client that a suspicious transaction report may be made to the FIC. It would enable the accountable institution to discontinue the customer due diligence process and consider filing a suspicious transaction report. Section 21D of the Act deals with the process to be followed by accountable institutions when there are doubts about the previously obtained customer due diligence information from a client. And this amendment would extend this obligation to pursue certain processes to instances where a suspicious transaction report is made to the FIC. And then clauses 37 to 42 provide that there would also be potentially additional administrative sanctions that could be imposed for failing to comply with particular provisions in the FIC Act where a possibility for administrative sanctions was not previously provided for. And then in the tabled version of the bill, there are proposed amendments relating to the beneficial owner definition in clauses 15 and 19 of the bill, and it is an amendment to try to ensure that the definition encapsulates every natural person who is a beneficial owner of a client that is a legal person, partnership, or trust. This is to provide for what's referred to as the look-through principle. And Section 21B is amended to provide for instances where partners in a partnership or trustees or beneficiaries of a trust are legal persons. And the amendment to Section 21B4, subsection 4, relates to the additional customer due diligence measures that would need to be taken in respect of all parties to a trust, in particular founders, trustees, and beneficiaries. Then there are some amendments that relate to politically exposed persons, and these are in clauses 44 to 40 and 44 to 50 of the bill. And Schedule 3A currently lists designated domestic prominent influential persons, and such individuals are those that currently hold, including in an acting position for a period exceeding 6 months, or who has held the position at any time in the preceding 12 months. And so the Schedule 3A would be amended to rather, instead of referring to domestic prominently influential persons, to rather refer to domestic politically exposed persons, and also to provide for those individuals to be considered domestic politically exposed persons if that person currently holds or has held as the specified positions at any time. And in respect of individuals listed in paragraph B of the schedule, the amendments provide for a new Schedule 3C, which refers to prominent influential persons. And an individual would be considered to be a prominent influential person if the person currently holds the position, including in an acting position, for a period exceeding 6 months, or who has held the position at any time in the preceding 12 months. Schedule 3B lists individuals who are currently considered to be foreign prominent public officials, and these would be amended to, the schedule would be amended to rather refer to foreign politically exposed persons, and also the schedule would be amended to delete the term at any time in the preceding 12 months. And so an individual would be considered to be a foreign politically exposed person if the person currently holds or has previously held the position listed in Schedule 3B. And Section 42 extends the obligation to provide for the manner and process by which an accountable institution determines whether an existing client is a foreign or domestically politically exposed person. Then there are some amendments relating to the risk management and compliance program in clause 36 of the bill that amends Section 42 of the FIC Act. And Section 42 is amended to provide for the requirement that accountable institutions must take into account proliferation financing risks when developing its risk management compliance policy and program, Section 42 also is amended to provide for the manner and processes by which group-wide programs of an accountable institution or for all its branches and majority-owned subsidiaries is implemented so as to enable the institution to comply with the requirements of the Act. This also extends to the exchange of information within branches or subsidiaries relating to the analysis of suspicious transaction reports. Institutions would also now be required to have adequate safeguards to protect the confidentiality of information that is exchanged. Section 42 also provides for the additional obligation for the accountable institutions to provide for the manner in which the accountable institution will apply appropriate additional measures to manage the risks if the host country does not permit the implementation of measures required in terms of the Act. And then there are several clauses that provide for amendments relating to targeted financial sanctions. And the definition of proliferation financing is added consistent with the term being introduced throughout the amendments contained in the bill. Section 26A is amended to provide for the resolutions of the United Nations Security Council to become enforceable immediately on the adoption of a resolution. And Section 28.6B would prohibit, among others, any person from transacting with a person or entity identified in terms of a resolution of the UN Security Council. And this prohibition would be extended to also include persons who are acting on behalf of or at the direction of the designated person or entity. Then there are proposed amendments relating to Schedule 2 of the FIC Act. And so Section 75 is proposed to be amended to enable the minister to have a power to add to the list of supervisory bodies in Schedule 2 of the Act, a supervisory body which will be responsible for supervising and enforcing compliance with the Act. And the amendment also would make provision for the minister to delete a supervisory body from the schedule if the minister reasonably believes that the supervisory body is no longer satisfactorily performing its supervisory or enforcement functions in terms of the Act. And then also the references currently in Schedule 2 to the State Agency Affairs Board and the provincial licensing authorities would be deleted, and the FIC would then be responsible for supervising and enforcing compliance of the Act for both the state agents and the gambling sector. Section 4 would be amended by removing the reference to accountable institutions being regulated by any other law consistent with the recent amendments to Schedule 2 that removed a number of supervisory bodies and for which the FIC is now responsible for supervising and enforcing compliance of the Act. Then another small set of amendments relates to the Companies Act, and the FATF recommendation highlights that it's essential to ensure that there is adequate, accurate, and up-to-date information available on the beneficial ownership and control of legal persons that can be obtained or accessed rapidly and efficiently by the authorities through either a register of beneficial ownership or an alternative mechanism. And so the main deficiencies that are sought to be addressed in the amendments proposed to the Companies Act relate to the findings that beneficial ownership information is not always timelessly available to the authorities. So Clause 52 proposes to insert a definition of beneficial owner, and this definition again specifically is tailored to be appropriate for the particular terminology and context of the Companies Act. Clause 53 amends Section 33 of the Act to provide for a comprehensive mechanism through which the Company and Intellectual Property Commission can keep accurate and up-to-date beneficial ownership information. And Clause 54 inserts a new subsection 3A in Section 50 to provide for a requirement that a company must keep records of the natural persons who own or control the company as per the definition of beneficial ownership, and to provide for timelines within which the company must record any changes in this information. Clause 55 amends Section 56 to insert a new subsection 12 that provides a requirement for a company to file a record of the natural persons who own or control the company as per the definition of beneficial owner with the Companies and Intellectual Property Commission. And Clause 56 amends Section 69 to insert references in subsection 8.4 to also include references to offenses relating to money laundering, terrorist financing, or proliferation financing activities as they are defined in the Financial Intelligence Center Act, and also offenses in terms of the Paktatara Act and or the certain offenses relating to the Tax Administration Act. And then Clause 57 amends the arrangement of sections of the Act. Then the final provisions of the bill includes some amendments to the Financial Sector Regulation Act, and Clause 58 amends Section 159 of the Financial Sector Regulation Act to provide that a financial institution, a key person, representative, or contractor, as defined in that act, to which a regulator's directive in terms of Part 2 of Chapter 10 has been issued must comply with the directive. Clause 59 inserts a new brief Chapter 11A and Sections 159A to C in the FSRA dealing with beneficial owners. So Section 159A would provide for a definition of beneficial owner for the purpose of the chapter, and that is defined how the term would apply in the specific context of financial institutions. And Section 159B addresses, empowers making standards by the regulators in relation to beneficial owners. And Section 159C empowers regulators' directives to also be made in relation to beneficial owners. So this will enable the financial sector regulators to begin to implement some appropriate regulatory measures in relation to beneficial owners in relation to the financial sector regulatory framework. And then the final two clauses of the bill amend the long title of the act and also to amend the arrangement of sections of the act of the FSRA. And so then Vukile can perhaps come in again just on the final timelines for the FATF process.
Just go ahead, Janine. I'll deal with this in the conclusion slide as well.
Okay, thank you. So as Vukile has alluded to previously, to some extent in his previous presentation, so at the end of October, the observation period for South Africa ends at the FATF plenary, and then FATF will inform South Africa of detailed timelines for steps that will need to be taken in the POPR process. And then in December, the joint group will send the draft POPR to South Africa, and South Africa will need to provide a written response to the draft report. Then in January, early January, there will be face-to-face meetings that will take place. And then in mid-February, then there will be an action plan that will be adopted by the ICRG and FATF. And so this was sort of setting out the legislative process in relation to the Paktatara and the bills. So I think Parliament's aware of that. So I think we can go to the conclusion. Vukile, would you like to come in?
Yes, thank you, Janine. And thanks for taking us through all of that clause by clause. So, Chair, thank you. That's the presentation. And just maybe in conclusion, just to make a few closing points. The first is that South Africa can demonstrate that we have made significant progress in taking remedial steps for technical compliance by February 2022 if we enact the bill and have it in force by December, January. And Chair, as I mentioned, this is a critical and necessary component to avoid grey listing. The key challenge is that we pass both of the bills this year. We can show and demonstrate progress in October already by being able to demonstrate to FATF that the bills are well on their way to to enactment by the end of the year, by being passed by Parliament. A key process and challenge for both this committee and the Standing Committee in the General Laws Amendment Bill is how to to ensure sufficient coordination with the other portfolio and select committees who have an interest. But Chair, you would have seen in the earlier slides that we have on the executive side, on the departmental side, been working very closely with those departments. We will also have to show significant progress in addressing effectiveness, Chair, by 2023 February. And I mentioned earlier that's going to be a significant challenge, but we think we will be able to do that, and that across the various investigative, prosecution, regulatory, all those different stakeholders relating to the IOs have made significant progress there. We will need to develop action plans for each of the effectiveness measures, Chair, but we do overall believe that we can prevent a grey listing because the consequences of not doing that, Chair, are so significant that we believe that it is critical, but more importantly, Chair, that we're working closely with yourselves, that we can meet the timelines necessary to do so. While, of course, Chair, respecting the rigorous role that this committee and as well as the Standing Committee have in ensuring that stakeholders are heard, that all permutations are considered, and that whatever outcome, legislative outcome is arrived at is able to withstand scrutiny and be fit for purpose. Chair, just by as a final statement, the steps taken to prevent grey listing will be in South Africa's interest. On two areas, Chair. It's not just about narrowly meeting the requirements to avoid a grey listing, although that is critical as we've described earlier. But we certainly believe that having a financial system that is able to adequately address risks from money laundering and terror financing are in the public interest and consistent with our own national interests. So thank you, Chair. We've gone down quite a road. We had submitted this piece of legislation to Parliament at the end of August. About a month later, the Standing Committee had undertaken public hearings, and there's been quite a few of those, and we have taken 3 rounds of comments and submissions in that process, and had many bilateral engagements with stakeholders, and made some enhancements that we think addressed their concern while meeting the overall objectives. And now, Chair, we will now obviously move the process. Well, the process is very close to being concluded there, hopefully, and then now the process shifts to your committee. Chair, that's it from us. Thank you for allowing us the time to go through this presentation.
All right, thank you very much. Members, please note there are all the other documents which set out the issues raised by stakeholders and the responses of National Treasury, and we need to go through that between now and the time we meet again. Right, so over then to members. Hands up, please, so I know who. Yes, Gertrude Fester. Sorry, who would be?
My name is incorrect on the screen. I'm logged in for the staff members.
All right, well, we know who you are, but who's Ms. Fester? Is she a member from which committee?
No, sorry, Chair.
I think that's Mr. Ryder.
Yeah.
Ah, hello, okay, Gertrude. Oh,
Gertrude.
Miss Fester. Okay, right, Mr. Fester then. All right, fine. Then it's funny. Other hands, please. Let's go on. In the meanwhile. your issues. Dennis.
Chair, thank you. Good. My apologies for that naming error on the screen. Good. Thank you very much for the presentation and the update, I guess we can also say as well. But I think that important to note is that there was an October report that needed to be submitted, I presume 3 days ago or so. If you can just give us some idea in terms of the feedback, I think that's the important aspect that we'd like to hear about is when can we expect feedback from the FATF in terms of that submission to just tell us exactly how we're doing in terms of the requirements. So that would be the one thing I'd like to ask. The next item relates to that beneficial ownership and the fact that this has been indicated to be quite a problem when it comes to trusts specifically, and the fact that these vest with the Master's Office in the courts. Now, there's a change, obviously, to bring this into the CIPC. What is the level of cooperation between the Department of Justice and Constitutional Development and Treasury in terms of arranging this transfer, and what are the plans on that? Is that materially made up in the contents of the bill? I don't think that was spelled out. I may have missed it. I have had some issues connecting earlier on. So, but if you can tell us around just the switch in the control and the management of the trusts, because I think under the master it's been certainly a largely paper-based control mechanism, and I believe that under CIPC it's going to be a much more focused and electronic system. But you know, where are we in terms of those discussions, and is there a timeline on that as well? That's the second question. In terms of the amendments, I mean, again, we're getting into quite a technical space, and I think it's going to take quite some analysis. So I'm not going to try and show my ignorance by commenting broadly on that. But again, the biggest issue, and I think Mr. Davidson kind of spoke to it at the end here, is the fact that we're not just doing this in order to meet the FATF's requirements, but we're also doing it because it's probably a good idea to do in terms of protecting our economy and safeguarding law-abiding citizens and law-abiding South Africans from you know, further financial transgressions and illicit flows and all of those nasty things. So in terms of the implementation, I think that's the key, is that we can have the best laws in the world, and the point was made when we passed the regulations, the report on the regulations to the current FRC bill. The question is, in terms of the implementation, what are we seeing in terms of heightened cooperation between, for example, the FRC, Customs, SARS, South African Reserve Bank, Prudential Authority, FSCA, the Hawks, the CIPC? So we can pass the legislation, but what are we seeing in terms of practical, or what's being proposed in terms of practical maneuvers? Is this act really dealing with how those entities should be talking to each other and how they should be reacting to the information received and reacting to the reports that are received? Because I think it's quite clear that the FRC has previously received a lot of reports and not necessarily acted on them. Thank you, Chair.
Next, I mean, you know the order, it's funny, and then I see no other hands up. Okay.
Thank you, Honorable Chair. Excuse my video. Honorable Chair, I won't be long. I'm not going to go into the technical aspects of this. Chair, I'd want to know, with regards to this all these legislation that is only appearing before us now, if Treasury can maybe just tell us or enlighten us what happens or who's to be held responsible. Is there a specific person, or is it a specific department? That's the one question. I'm going to tie on to what Honorable Ryder said with regards to implementation. I'm appreciative of the timelines and the clarity that was given during this presentation. Obviously, I'm going to be repetitive. It said that if the legislation is passed in December, then we must start implementing it in January, and then we must start to see results in February. Now, when I refer to what happened during the COVID period with regulations and alterations to, or amendments rather, to legislation in the country, and what challenges were encountered to implement that, what is going to happen with regard to the implementation of this amended legislation? How will training take place? What will the monitoring aspects be? Who will do the monitoring, etc.? Because in all honesty, Chair, I can't see, and I don't want to be negative, but I can't see if this is put into place that we will be able to train all the relevant people in the different departments within a week or two's time to see actual results in a month's time. If we can maybe get clarity on that, it would be appreciated. And then lastly, should we not be able to meet this requirements or the estimated time schedules, which is then February next year, when is the actual cutoff date? By when will we know if we had succeeded not to be grey listed or not? Thank you, Chair. That's all.
Okay. Firstly, I haven't read the bill, colleagues and comrades, and I have browsed through, I must say, very peripherally, the slides presented, because I prefer to get a proper briefing first, and then I find it easier to read your slides. There's a lot I can say, not so much about content, but not so much about technical content, but about other issues that arise. But I think I should be guarded about what I say. And it's not very easy, believe me, but here it is, right, for what it's worth. So the first thing that strikes me as somebody who was around in the last term of Parliament in this portfolio on the other side. Well, firstly, the thing that strikes me, and I speak subjectively, I don't know whether others in my party will agree, but there's nothing wrong with me as a chair. I'm also a chair, I'm a parliamentary functionary, not just an ANC functionary, as a chair, as Dikeledi is in her committee, or I mean our committee appropriations that she chairs, as is any chair of a committee. So the first thing to say is that where there's not so important, where we're not in such a dire situation, I don't think any reasonable chair on the NCOP side particularly would agree to process this bill before we rise at the end of the first week of December, is it? So I don't think it's fair. Actually, you know what? Now speaking very subjectively, all the years I've been chairing, since 1998, I've never come across a situation like this. Now, Vukile and the team here are relatively new to Treasury, playing the roles they are. It's not directed at you personally. You do the best you can. Many of us know how you work, and there's a new crop of you coming up who are very bright and you know, very promising and encouraging. So it's not directed at you personally, please. But Treasury has to be held account once again. What strikes me is we amended the FIC bill not so long ago. I can't remember particularly, was it 2018? It was a torturous process. You will remember, Chini, how controversial that was, and the tricky waters, not least within our own party, that it's known all over the world. It's all out there in the public domain. I think the peasants in Mongolia know it. There's nothing I'm saying to this meeting that you don't know already in some or other form. No, not least the intricacies within our own party and how we are to manage the conflicts internally, let alone with some sections of civil society on the one side and other sections of civil society on the other side, both claiming to be more progressive than the other. But the point is, there wasn't an inkling at that stage, you know, that we're in trouble. We passed a Financial Sector Regulatory Act and we're making changes now. The scope and range of changes, it's really quite surprising, actually. And Fanny is right. Doesn't matter which political party says what. It's right. I mean, really, this is really unfair, especially on the NCOP, because I've just heard now, which is why I'm feeling strongly about this. I've just heard now, 2 minutes ago, thanks to a very efficient secretary, that your meeting with Treasury tomorrow will not take place because you're not ready. You have now postponed it to the 10th. If you look at our tentative agenda, the 10th was supposed to be our slot for public hearings on this bill. Now you must remember, Vukile, you can come and make those pious statements here. And it's not directed at you personally. Treasury can come and make its pious statements here. Yeah, you know, this is what will happen if we don't do it. No, we never once did the Treasury say, no, we're very sorry. Ultimately, it's your responsibility to have brought this bill. And the more I listen to Treasury, the more I realize you had many pointers to move on this. Now, we don't want to go on sort of like going for you. And there are some things that some of us will know about the internal politics in Treasury, right? And what also responsible, what's also, ultimately it's the politicians, the former minister and the current one. And to some extent, the acting DG, because this is his area of expertise, but mainly the two politicians that are affected, maybe three. It's difficult to tell because we have this endless change of ministers for such an important portfolio. But we are where we are, and we will do what we have to do, and we will get this bill through. But please remember, not at the expense of somebody taking it to court, and then they go up to the highest courts, and it's held up, and then we're embarrassed because ultimately it reflects on Parliament if a bill is rejected or clauses are rejected. It's going to mean to FATF and whoever else internationally out there, we can't even get our act together. And the Parliament, let alone the executive, has failed. Now, basically, colleagues, you know what we're talking about now. They will only meet next Thursday, the 10th, which means they will vote on that bill early the following week if all goes well. And there's a big cluster of bills, as you know, towards the end of the year. So when are we going to have our public hearings? The earliest is the week of our study tour. Now, what Mr. Ryder said to me, I raised it in Kululeka, I didn't quite follow him. He said, you know, we should stick together because we might have things to attend to, and whether if we're going, I think he implied in Kumbi's, then maybe the SCOF and CCOF, I mean, CCOF should be in one group because we might have to meet. So it is now in Kululeko, start activating this. What I'm suggesting, colleagues, and if anybody objects here, please raise it, and we'll have to decide as a majority. The week of the study tour, we go on it, right? We can't keep escaping our responsibilities to go. We did it in January, but you know, still, when did we go? To our provinces, right? February, I can't remember. Yeah, okay, whatever, February. We have to go now. But what we can do in Kululeko is seek exemptions from some of the cities. We can meet after hours in Kululeko. We can talk offline with the whip of our party and the opposition members and finalize it. But you know, if you get people who have been out in the field and attending meetings all day, and then you want to have a meeting at 7 p.m., I mean, it's tough. People's concentration levels are low. So we can seek exemption. I will negotiate that if the committee agrees with the chief whip and the chairperson of the NCOP, that there are some sessions, maybe in the morning we exempt and we join them in the afternoon. So we look into that. So we will have to have hearings in that week that we are on a study tour, or what you call it, taking Parliament to the people. So on that matter, I'll ask people to comment in a moment from the committee, from all parties, including our whip, Marakhane. Then the thing that, well, I think others have raised this anyway. What strikes me is that we've passed really good legislation, from what I can tell. The FSRA is highly valued. It's not because of the committee so much as the quality of the bill you brought. I mean, I've seen comments on it and so on, and we took many months to process that bill, right? And here we are making all these changes, right? So what happens now? We pass all these bills and you don't monitor it. And the issue that arises is now we're going to pass all this legislation. That's not going to buy anything. It's a commitment. If we don't implement it, if the FIC and other supervisory financial institutions don't do their jobs, if the Hawks and the NPA don't do their jobs, we're going to be back to square one. So I think those who are raising this thing about, yeah, we can pass these bills, so what? I think we can do it. The president has on previous occasions very quickly promulgated a bill into an act. It's happened before, Fani. Some of your researchers might draw your attention to that. I'm not sure about COVID, what exactly happened, but you seem to be more familiar with that. Then you ask about our relationship with the other committees. I think we should take our cue from SCOF. From what I can tell, SCOF did not engage with the Justice, Police, Social Development, and other relevant committees. Am I correct, National Treasury? And I'm wondering about how we're going to do that, because these committees have got bills. Justice has endless bills, right? And it's the same committee, I think, that does, is that right, in Nkululeko, Justice and Police? I think it falls in the same. How are we going to get them to come to a meeting? Social Development is in a cluster of 2 other committees. I don't know how we'll get them. So can we discuss this offline, but can you give us a response now to how the SCOF handled it? Because we'll follow that cue. If they passed it like that, then I think we should go the same route, because let's be frank, I can't see, with due respect, if I was in Justice or in Social Development, that even as a chair, I'm going to be as familiar with these issues as finance people are. So we can go through it nominally and symbolically by bringing 2 members in with joint structures. I don't know how we're going to get 3 committees to meet together, but let's see what's SCOF did, and you'll let us know now. Then finally, comrades, colleagues, we have to read a lot about this. And to start off with, the norm, as I understand it, in the committee section is when it comes to a bill, it's the researcher from the research unit that does an overview and raises issues. And then when it comes to the writing of the report, it's the content advisor. But I've had the meeting with the staff, and we all agree that we shouldn't, in times like this, of duress and urgency, have like silo mentalities. And the team has been working quite well. And the last report was a wonderful one, as even the opposition members said. And that's the quality of our senior team. You're hoist by your own petard is the English expression. I'm using it twice today. But anyway, and so, we'll expect, you can start working as with Poppy with a draft, because this is more or less the key features in the bill. And whatever happens next Thursday in SCOF, you can catch up on that. But we would like very soon, but certainly by the following Monday or so, let's separate for the public hearings, but if you can do us a draft before that, it's great. But even before the public hearings, raise some issues, and then you can add more and expand the report with the cooperation of your 2 colleagues there on what people have said in the public hearings. Then finally to say, there were Treasury, 2 at least people who contacted me to plead. And these are good people, progressive people who mean well, who said they're very unhappy with what you're doing. And then I saw some of it in the media. NGOs were upset, like being so petty about what you're prescribing, swinging from the one extreme to the other, being almost draconian. Now, these are people I respect for what it's worth. And they reached out to me, and I explained the bill is not before us. And frankly, the main port of lobby, so to speak, is the NN committee. So I saw later in the media, and I'll catch up on what happened at SCOF when they finally vote on it, that you did make concessions to them, and we will all read those things. But we would like to go carefully through those long overviews of people's submission. But first and foremost, let's see what comes up in public submissions to us. Maybe you've dealt with most of the issues and we'll get few submissions. Maybe people are not happy and they'll come to us. But when we've dealt with our own submissions received in the NCOP side, we will then look at what happened on the NA side too, because I pick up things that they don't. Now, we also have to process this fairly swiftly. That means not spending few hours, but condensing time and sitting for long hours if we have to, and exempting us as much as possible from the house if there has to be. I don't think that will be a problem. But if we make changes, or if we pick up things that require changes, that are mild even, it has to go back to the NA. So, we have to take that into account because they normally end their term a week before we do. So there are all these imponderables. I really don't think you can come here, Bukile, with due respect to you and stress the urgency if you can't deliver on the SCOP side. And it's not even a postponement from tomorrow to next Tuesday. From what I can gather, you're asking for a postponement to next Thursday. That's a whole week lost now. So, these pious words from Treasury are not reflected in your practice. Why can't you also work, if you work 25 hours a day, 27 hours a day? Why are you putting us under duress? So really, this is not acceptable, really. We will do it because we have to. But it's only because we have to. I'm telling you, otherwise, no NCOP chair, worth his or their salt, would agree to process a bill like this. Remember, we've got your tax bills. So really, this is really unacceptable, but we will do it. What's the English expression? Come hell or high water. I don't know if that's politic or diplomatic to say here, but I can tell you, getting this WhatsApp now from our wonderful secretary has really upset me that you want another whole week, which means, I'm repeating this, but it's really frustrating, really. Okay, fine, I've said what I've had to say. Can members respond to the process issues I've raised? And before that, let's have your response to the technical issues, Treasury, and then the members can respond on how we go forward and how we manage this process. Thank you.
Thank you, Chair. Let me start off by maybe just first of all thanking yourself, Chair, and of course the SCOF Chair. Your approach has been incredibly flexible and accommodating, and we highly appreciate the flexibility that you've afforded us, given this sort of unique bill that we're trying to process. Chair, I'm not going to try and justify the delays, but perhaps merely try and describe some of the complications and dynamics, Chair. And I think that one of them you had described yourself. The omnibus bill, which covers five pieces of legislation, many of which, Chair, are stakeholders in areas not traditionally within the finance portfolio, has required us to go a little bit more carefully. We're less familiar with some of the stakeholders, so we've really tried to very carefully and as much as possible with multiple engagements understand the core issues, including the one that you raised, Chair, in relation to the NGO sector, and having to work through multiple in multiple sessions how we can accommodate and ensure that their concerns have been fully addressed, Chair. And this is in large part why we have requested some additional time, is to try and address these concerns, and some of which ourselves, Chair, we had received relatively late, and then there was obviously some back and forth. It's not to assign a blame, Chair, or at least, and certainly not to absolve ourselves. It's just that to describe some of the complexity and challenges that we've faced, but we've certainly really appreciate the flexibility that has been shown in not just your committee, not just in this law, but in processing the schedules, which is another indispensable part of the measures that we need to address the grey listing problem. Chair, I'm going to hand over to some of my FIC colleagues and Janine to address two sets of questions which I think we can address simultaneously. There's some common themes. The first, if Peter could just maybe sketch out the FATF process and the key dates and when we're going to receive feedback, and then as well just describing the views relating to beneficiary owners, specifically the reference to trust. And then there were questions asked by Honourable Ryder and the Honourable Member from Freedom Plus on implementation to demonstrate effectiveness. But you know, Chair, what as you would have seen in the presentation, you know, for better or for worse, we will be measured not only by the laws in place, but we're going to have to demonstrate effectiveness. So there's almost a requirement that passing the law is only sort of the price of entry, and then we've got to really demonstrate how we're going to be effective, and that is something we're acutely mindful, as Peter describes, how we're going to balance those two aspects. Finally, yeah, so those are the questions that I've received. There was another additional question about the timelines and processing the bill, which I part answered in the introduction, but we had introduced the bill at the end of August with the standing committee calling for or having their first session for consultations around the end of September. We've had multiple rounds of that. There was an extension in that process as well to accommodate comments from broader set of stakeholders, and then we had another round of interactions. So I hope that at least covers the Honourable Member from Freedom Plus. But Peter, can you come in on FATF process, the trust issues, and then some of the implementation questions?
Thank you, Kelly. Good afternoon, good evening, Mr. Chair and honourable members. Unfortunately, I was driving home from the Gauteng train station just now, so I missed some of the discussion. But just to pick up on the FATF process, we received communication from the FATF Secretariat in the past few days, outlining the process for us to submit our information to the FATF. They expect our report on the work that we've been busy with for the past year or so at the end of November, in the last week of November. They will then engage with that report, the information that we will submit, and it will include the information both on the amendment process with this bill and the Pakatara amendment bill that's also currently in Parliament. And it will also include all the information on the other actions that we've been busy with on the improvement of effectiveness. And this includes things like improving the investigative capacity, prosecutions of complex money laundering cases, our capacity to supervise compliance by financial institutions, and so forth, the risk assessment work that we've been doing, etc. So we will then have a first draft of the review team's assessment of that material and engagement and further clarification over the first 2 weeks of December. And then we will meet with the review team around the second week of January. And that will be a face-to-face discussion with the review team based on the material that we would have submitted by then, plus any further updates to that information that we would be able to provide. And that discussion will be focused specifically on understanding the review team's assessment of our information, and engagement with them on their views of whether we've made sufficient progress or not, and also providing any further clarification or answering further questions that the review team may have. That will be a meeting of around 4 to 6 hours, maybe spread over a day or two with the review team. And based on that engagement with the team, the final report with the recommendations from the review team will then be discussed in the February plenary meetings of the FATF, where the FATF will then make a final decision on the progress that South Africa have made over the period until the January meeting. The work that we've been busy with it was not only focused on the bills, this General Laws Amendment Bill, and also the Pakatara amendments to address legislative amendments. We've also been very hard at work with a wide range of authorities, government departments and agencies, to complete a second round of our risk assessment process. There's a report that is ready for consideration by our Directors General and heads of organizations. That should happen in the next few weeks. The work on formalizing a strategy to deal with money laundering and terror financing based on that assessment of risk is also fairly well advanced. Will also be considered by the same principals in the next few weeks. And there's been a lot of work happening on the side of the engagement with the supervisory authorities, especially with the Prudential Authority and Financial Service Conduct Authority that is responsible on the 80-20 principle for the major portion of our institutions that have to comply with the anti-money laundering requirements. We've also been very busy with formulating new guidance to financial institutions and others that have to comply with the FIC Act on various aspects that they have to address. And there's been significant engagement with the investigating and prosecuting authorities in improving the priority and the numbers of money laundering investigations that are currently underway. And there has been a fair amount of success also on the prosecution side with cases from what we have established as a fusion center, where we've co-located investigators, prosecutors, and officials from the FIC in one environment where they've been conducting investigations relating to COVID, diversion of funds, procurement fraud, etc., that happened around the COVID relief work, and where a number of prosecutions for money laundering charges have been laid and successfully completed and convictions achieved. So there's been a significant amount of work in addition to these amendments to the legislation, and all of this have to be presented to the FATF in the context of the follow-up report. These technical corrections that we have to make to laws through these amendments address the findings on the standards of the FATF that relate to customer due diligence, terrorist financing, and especially the issue of beneficial ownership, which has been pointed out in a number of areas as a factor that impacts effectiveness across a range of the areas where we have to improve. So we are confident that we have made a significant effort. I think an effort that has surpassed what many countries have done in the space of time that they in these follow-up processes. On the beneficial ownership, Bukile has asked me to touch just on that. One of the significant points of discussion in the last few days, weeks, around the proposals in the bill on beneficial ownership has been to accommodate a solution that works for public companies in the requirements to obtain and disclose information that can be used in a register that will be a central register that can reflect the beneficial ownership of companies. In the bill, as it was introduced, there was an obligation proposed for all companies, public and private, to obtain information about their own, each company's own beneficial owners. In other words, the natural persons that ultimately own and control those companies, and to disclose that information to the Companies and Intellectual Property Commission, where the information would then be kept in a register. In the discussions in the process of the Standing Committee on Finance and the commentary that was received in that process, it was pointed out by a number of commentators that this would be a very difficult task for public companies because of the frequency in share trading on the exchanges such as the JSE and the other exchanges where public companies trade or shares are traded in public companies. And because of that, we had to then have a very detailed discussions and very fine detail of company law and the requirements for public companies that we have available that we can work with in the Companies Act and in the manner in which company share information is recorded and registered. And based on those discussions, we have been able to come up with alternative proposals that would work or enable us to obtain information about public companies that would contribute to the information on beneficial ownership for public companies alongside private companies. So that's been a fairly detailed piece of work that we've been trying to accommodate in the commentary and find alternative drafting proposals for the Companies Act. A very technical area that is required a bit of expertise also being brought in from the CIPC and the DTIC in helping us formulate these solutions together with the commentators from the public side. So Bukile, I hope that has addressed what you wanted me to address. As I said, I've unfortunately missed some of the discussion while I was trying to connect just now. Thank you.
Are there any further responses from Treasury side?
Honorable Chair?
Yes.
I will provide some responses to a couple of the specific queries.
Okay.
Firstly, in relation to the very pertinent question about, the registers and the coordination of the registers that are to be established in terms of the legislation. Unfortunately, our colleague from the FIC who's been involved in the specific process isn't in attendance this evening, but there is a beneficial ownership national registry framework that is being established, and there's a work stream that is looking at establishing the registry framework to enable the registries, various beneficial ownership registries, to provide access to law enforcement and other competent authorities through an integrated and harmonized two-tiered national beneficial ownership framework that would include, firstly, a tier of central beneficial ownership registries, those held by the CIPC, and also a trust register under the Master's Office of the High Court. And then there would be a second tier of registers that would be falling under the first tier of registers of government data and asset repositories that will be prime users of the main registries. And then also they would produce other smaller registries that would enable a link of assets to beneficial ownership persons' data. And so that, this would relate to the properties deeds registers, the register of NPOs that will be operated by the Department of Social Development, and other public benefit structures that relate to tax benefits coordinated by SARS. And so it's envisaged that this would be a multi-pronged risk-based approach to provide for an integrated implementation of the beneficial ownership information of legal persons and the various registries within government agencies, including SARS. And so the CIPC would be a centralized repository of basic legal person information, and it's in quite an advanced state from a digital infrastructure perspective compared to other digital capability functions that are currently available. And so it's recognized, there will need to be work to develop these systems and infrastructure. And so, the CIPC will play a key role, particularly, in the establishment of the framework. And then to be able to result in a national integrated and interoperable and harmonized beneficial owners registry framework, then there will need to be develop the appropriate linkages between the master's offices and the CIPC and other registers. So this will be a key area of work that has been commenced and will be continuing. And so I think we can maybe give some further detailed feedback on this in a subsequent meeting when our colleague who is particularly involved in that work is able to attend. But maybe also one of our other FIC colleagues may be able to come in with a bit more detail in just a minute. And then in relation to the very pertinent question about coordination and the regulation and subordinate legislation that is envisaged that will need to be developed and implemented in terms of the legislation. During the development of this legislation, we've had a very effective and invaluable legal working group among the departments whose legislation is being amended. And we are continuing that engagement and work with the departments and also the CIPC, and will also engage with the master's office about, to coordinate the appropriate development and efficient and effective development of the regulations that are envisaged will need to be put in place in terms of the legislation. So we will certainly draw upon the processes that have been developed for the development of this legislation and really try to use those interactions to develop the subordinate legislation and promote its efficient promulgation and ensure that the subordinate legislation is appropriately integrated and aligned. So I don't know, Peter, or would you like to come in further on any of these questions?
Thank you, Janine. I see Christopher also wants to contribute, but I think from our point of view, you've covered well what the framework is that we are looking at establishing for providing the resources to find information about beneficial ownership of companies and trusts. But I think Chris may have something to add to that as well.
So good evening, Honourable Chair and members. So I'm Christopher Milan, an executive in the FIC, and I just want to pick up where Janine mentioned the other official. I happen to be that official, and Advocate Peter Smith and I have just returned from a parliamentary briefing, and we were travelling, so we were a bit late. My role in this is as co-chair of an interdepartmental committee on beneficial ownership transparency. And essentially, this is the committee that is going to do the nuts and bolts of designing, implementing the registry framework. So I won't repeat that. It's been well laid out by Janine in summary. I just want to pick up on Member Ryder's question about the movement of the trust registry to the CIPC. I think that's an issue that needs clarification. And the current formulation is to have a tier 1 grouping of registries, with the CIPC being the lion's shareholder of that beneficial ownership for legal persons, and it will be supplemented and complemented by the various masters registries in all the provinces under the chief master. So at this stage, the bold, with all the consent of governmental players, is not to be moving the trust registries to the CIPC. It is going to be linked to the CIPC data through an interoperable integrated framework, which would have to be built on an IT platform. And all the master's offices information would be available online. There would be an extension of the Masetti information available now. So, Member Ryder, we are not contemplating the movement of the trust registries to the CIPC at all at this stage, in fact. So the bold question that was raised, how long would it take to implement the registries? Our best estimations, based on discussion with the ICT personnel in CIPC, is that it could take anything up to 18 months to put into effect the registry in an efficient form to start to gather the beneficial ownership information. There was another point which perhaps we need to deal with, was the question about the October FATF report. What happened to that? I'll ask Advocate Smith to come in on more detail. That report was duly tabled. It was mainly on technical compliance. It was an update of where we are as at that date. It was tabled at the FATF, but because we did not ask for any rating changes, because there were further amendments in the process, which, as you know, the scope issues were being dealt with. We were merely advising the, the FATF that we have made certain progress. Obviously, after completion of the amendment to the schedules, we will have much more information to table and then ask for the rating upgrade. But I'll pause there and hand over to Advocate Smith just to deal with the finer detail on that. And I can come in, Janine and Ukili, on the supervision issues and implementation if you would like me at a later stage. Thank you.
Thank you, Christopher. So, yes, we did submit our first progress report in the FATF's follow-up process in preparation for the October meetings. That report outlined our planning for the correction of the technical deficiencies, and basically this process of amending legislation, the two bills that are currently in the parliamentary process, as well as the expansion of the scope of the FRC Act through the amendments of the schedules to the Act that the Parliament had recently completed the process of considering the Minister's amendments. So all of that information was provided to the FATF in that follow-up report. The FATF took note of that. There wasn't any real comment or discussion on it at the point because the work is still in progress, or was at the time when the report was submitted. Since then, we've now completed the amendment to the schedules, so that will be a further update to the information that the FATF will be considering in our meeting in January. As this process, the current process of the amendments to the legislation with these two bills also further unfold, that information will also be further updated in the reporting to the FATF. The FATF only considers legislation that is in force when they consider the progress that the country is making. So anything in the process of bringing legislation into place, parliamentary processes, etc., leading up to the enactment of the legislation would be considered to be work in progress in our reporting to the FATF. So that was the status that we reported for the October meetings. The FATF took note of that. There was no negative comment that we are not adequately working on the follow-up work, but obviously we could not ask for any changes in the FATF's ratings as the legislation still, the legislative processes still need to run their course. Thank you. Akele, thank you, Christopher. I'll hand back to you.
Thank you, Peter. That's all from us, Chair. Thanks so much.
Okay, excuse me. So unless there are follow-up questions for now, and I don't see any hands up in Kululeko, do you? Ah, Mr. Ryder.
Mr. Ryder.
excuse me. Yeah, go for it.
Thanks, Chair. So I got two pertinents out of Advocate Bednar. So I'll wear those like my children used to wear the gold stars that they brought home from school. But just, yeah, noting that time, Chair, I think we need something on a lighter note. And I just wanted to ask, I wonder how many South Africans are excited about the consequential implementation of an integrated and harmonized beneficial ownership information framework. Maybe you've got some inputs on that.
Anything
That's
else,
the
Dennis?
task you give us tonight, Mr. Chair.
Sorry, I lost you there.
So that's the type of jargon we've been hit with tonight. I had to go back on YouTube and to hear about the consequential implementation of an integrated and harmonized beneficial ownership information framework.
Yeah, well, I've been here since 1994. Don't complain. Okay, over to you, Bukile.
Thank you, Chair. I just to check, are you seeking a response from Honourable Ryder's question on?
Well, if you want to say anything.
No, I don't.
All right. Okay. All right. Then in that case, colleagues, can we focus on the process issues? I see a chat group's got something. What is it? Ah, okay. Dennis being semi-facetious. Okay. So firstly, the suggestion is that, excuse me, that we have the public hearings, Nkululega checks when they're going to take it to the NA in the week that we are in the taking Parliament to the people, right? And then, so we find a slot there in Nkululega. We can only do it, I think, if the bill is tabled before the House. So you will sort that out and consult with Frank about the legal implications of what we're doing. We're going to do everything above board. So we can do it in that week, fine. In which case we will seek to find an exemption from the sittings or the field visits we're doing for one morning at least. And if it means 2 mornings, so be it. So let's see where we are next week, Thursday. I don't know what can be done about ensuring that the House moves swiftly on the NA side to process the bill if it is passed by the committee next Thursday. So hopefully on the Tuesday. But that is something, Bukile, the minister can engage with the Speaker's office and the committee chair on the NCOP side, because we are getting very worried on our side. So are we agreeing on that, that we'll see to possibly seeking an exemption for at least one sitting in the week we're going to the province?
There's a hand from Honorable Deutsche.
Yeah, Fanny.
Honourable Chair, thank you. Chair, on the WIPS Forum WhatsApp group, we received a communique yesterday, which stated that the Chief Whip was postponing the whippery and programming meetings until next week to get sufficient time to finalize all political and administrative arrangements for this taking Parliament to the people. Now, initially in the programming, it was stated that this would be a hybrid visit to the province. And it seems as if things have changed, but we haven't been informed or duly informed with regards to the latest developments. We must also keep in mind that we're supposed to give feedback to the provinces on the Division of Revenue Amendment Bill during this time as well. So I would be in full support of the hybrid attendance of this taking Parliament to the people, seeing that these bills obviously needs to get passed, and our committees respectively are under such tremendous pressure at this stage.
Yeah, okay, all of these permutations, I didn't know. All I know is that they consulted with the KZN, across political parties, obviously, delegates, about 2 weeks ago, with the Chief Whip's office and the NCOP chair. And they didn't tell us that it's a hybrid. So you know more than I do, certainly. I understood it to be fully physical. In any case, I'm in KZN, and Msandusi is about 2.5 hours at most, about 2 hours, 15 minutes. So I will go there physically, but obviously can connect through the virtual process with people, whether they're there physically in Potchefstroom or not. I think we're staying in Potchefstroom, but I don't know where we go, and so I'm not really clear about the program. I think it's still being processed. But anyway, I see another hand up.
It's still me,
Is
Chair.
that-
I don't want to keep the
Yeah.
meeting. I just
Yeah,
want
no,
to
sure.
correct something. This wasn't discussed across all political lines. This was, there was a steering committee that was compiled, not
Right.
representing all political parties.
Oh,
So obviously, everyone wasn't informed about the latest developments. That's all, Chair.
okay, all right. So you know more than I do, obviously. And what you think is more likely to be correct. But Nkululeko will work on that and look, he's great. He will work around all these things. He always does. And he will sort something out that suits all of us. And there's nothing more for me to say, except that when we come back from the, after whether we go or not physically, when that's over, then we will have to seek exemptions from the House and sit for full days if we have to. And I don't see any problem with that. But now the difficulty comes, obviously, with the smaller parties where you're taking part in debates that are not within finance. And then we will have to give space to you because you have a right to take part in those debates, and means suspending it while you're there or whatever. We can negotiate all of those things offline. Or having said that, I have nothing further to say. Is anybody else who's got anything to say? Nope. There it is. We're all for now. Thank you, Vukile. And I must say, Vukile, you are welcome in my view anyway, and the committee that I chair, to also get angry with me and get cheesed off and say, but you're not being fair, chairperson. There's nothing wrong with that. There's no rule that says you can't say, chairperson, you're not being fair. You're being tough on us, but you're not looking at our issues. Your acting DG does that, but he feels free to do it because he and I know each other since the, I think, early 80s. And he's been a former political activist, as you know. But you know what? Nothing stops you. It's your right. Sometimes a chairperson or a member can be unreasonable. There's nothing wrong. There's no rule in Parliament that I know of that says you can't. So having said that, I'm very struck, by the way, at how composed you are and how placid you are when Treasury is getting told off, so to speak, and rightly so in my view. And then you just respond and say, thank you very much for your comments. And thank you for being so flexible. Vukile, you should be in the UN or some Durko role. But we are glad to meet you, Vukile. You've come from nowhere and you're handling big issues here. And you're doing very well. So you know what, my friend? Janine, we know, right? So, I mean, Janine's an old hat, so she's like me. So it doesn't matter, Janine, although you're good as well, obviously. But what I want to say, Vukile, is I think you manage the select committee very well. And it's really something that is like encouraging. Okay, so it's not personal about you, Vukile. And it's, as I said, it's your acting DG we can target, the only official we can target. And maybe the previous DG, but mainly it's the politicians, it's us, my comrades, right, who served as ministers of finance, and whom I also know for many years, well, certainly the current one. Okay, Vukile, no hard feelings, my brother. Okay, bye then, all of you.
Thank you, Bye, Chair.
Thank you, Chair.
Recording stopped.